about judiciary, Nyayapalika. We hear about courts very often in the newspaper, and what this means when we say that law equally applies to all the person, and we have certain set of fixed procedure that need to be followed when the law is violated. So in order to enforce the rule of law in any country or in our country, we have a judicial system in place that consists of mechanism of courts that a citizen can approach when the law is violated. So judiciary is independent. So we have an independent judiciary. This is very important. So we'll talk about this judiciary, that is there any connection between the courts in your area and the Supreme Court. Then you'll also find various other things. This is the picture of the Supreme Court of India. So what is the role of judiciary? Before that, let me tell you that this is the Supreme Court of India. The Supreme Court was established on 26 January 1950, the day India became a republic. The predecessor was Federal Court of India, 1937 to 1949. So it was earlier located in Chamber of Princes in the Parliament House. Now it is moved to the present building at Mathura Road in New Delhi in 1958. So we were talking about the role of judiciary. Now courts are very important. They are taking decisions on a very large number of issues. That is, if some student is beaten or teacher is beating student, some sharing of river waters between certain state, they can also punish people for particular crime. So judiciary can be divided into dispute resolution, judicial review, upholding the law and enforcing the fundamental rights. So what do we mean when we say dispute resolution? The dispute can be between two people, certain people like citizens, between citizens and the government, and between two state government, or between the center and the state government. So the dispute resolution lies in the hand of the judiciary. Then we have judicial review. So because we know that the final interpreter of constitution, as the final interpreter of constitution, the judiciary has the power to strike down any law passed by the government which it believes that it is violating the basic spirit or basic structure of the constitution. This is known as the judicial review. Then upholding the law and enforcing the fundamental right. See, if anyone finds or he believe or she believe that the fundamental rights have been violated, he or she can always go to the Supreme Court and the High Court. We have learned about Hakim Sheikh, an agricultural laborer. He was injured from a train. Now he didn't get proper he was not admitted to the hospital, so he didn't get the proper treatment. So when this was heard under the Article 21, every citizen, the fundamental right of life also includes the right of health. So the Supreme Court directed the West Bengal government to pay him compensation for the loss suffered, as well as to come up with certain blueprint for primary health care with particular reference to treatments of patients during an emergency. So what is the role of the judiciary? We just saw that it is dispute resolution, judicial review, and upholding the law and enforcing the fundamental rights. What do we mean when we say independent judiciary? Just imagine a situation when you have a powerful politician and he has encroached a land which is belonging to you or your family. If the judicial hand or judicial system is in the hand or is in effect with the politician, then you cannot think of a proper justice to you. So in order to get that, the Constitution has made very clear that whether it is a rich or a powerful person, he may be the President of India or anyone, he may not influence the judicial process. The Indian Constitution protects against the kind of situation by providing the independence of the judiciary. Then we also learned about the separation of power. That means the branches of government, that is legislature and executive, they cannot, legislature makes the law executive makes the law execute, work. So these two cannot interfere in the work of judiciary. That is, the courts are not under the government. They don't act at all on their behalf. So this is the separation which we saw. And also the appointment in the Supreme Court, once they are appointed, it is very difficult to remove a judge, because there is no chance or possibility of interference of any of the legislature or executive people. So this independence gives the judiciary a very, a powerful state, and it plays a crucial role in protecting the fundamental rights of citizens, because anyone can approach the courts if they believe that their rights have been violated. So what is the structure of courts in India? Let me show you here. First of all, there are 3 levels. This is the first, second, third. Now third is the lowest level, first is the highest level. So lowest level or the lower level, we have subordinate courts and the district courts. Now these subordinate courts and district courts, they are usually at the district or tehsil level or in the towns, because they hear many kind of cases, and each state is divided into various districts that are presided by these district judge. Now each state has a high court. Each state has a high court which is highest in that state. India has 29 states. At the top, or the apex court, is Supreme Court. This is the apex court, Supreme Court, that is located in New Delhi and presided by the Chief CJI, Chief Justice of India. So all the decision made by CGI or Supreme Court has to be adhered or followed by HC and SCDC, and the HC decision has to be followed by SC and DC. So high courts, as we just saw, there are 29 states, but we have 22 courts. How that is possible? Because we have 2 states, that is Punjab and Haryana, they share a common high court. Then we have the northeastern state, Assam, Nagaland, Mizoram and Arunachal Pradesh. Arunachal Pradesh, they have a common court in Guwahati. Then we have Andhra Pradesh, and then we have Telangana. They have a common court. They have a common high court. So these all, see, I can show you the picture of High Court of Patna. This is High Court of Karnataka, and this is the High Court of Madras. So all these levels which we talked about, they are integrated. That is, and you can just understand that if something happens, something means in the high, say district court, something happens, some decision is there, then you can appeal to the next level. That is, you can go to the High Court. If some decision is made by the High Court, you can always appeal to the Supreme Court. We'll understand this by this appellate system. This is a very important system, appellate system, by a case which is the state against the Lakshman Kumar and others. In 1985 it happened. From the lower courts, it started with the lower court, and then it went all the way to the Supreme Court. So February 1980, Lakshman Kumar married 20-year-old girl Sudha Goyal, and they lived in Delhi with Lakshman brother and their family. On 2nd December 1980, Sudha died in hospital due to burns. Her family filed a case, and this was heard in a trial court. 4 of her neighbors were called as a witness. They stated that on the night of December 1, they had heard Sudha scream and had forced their way into the Lakshman flat, and they saw Sudha standing with her sari in the flames. They extinguished the fire, wrapping Sudha in a gunny bag and a blanket. So Sudha told them that her mother-in-law Shakuntala had poured kerosene oil on her, and that her husband Lakshman has lit the fire. So during the trial, the members of the Sudha family and neighbors stated that Sudha has been subjected to torture, and by her in-laws, and that they were demanding more cash, a scooter and fridge on the birth of the first child. So as a part of defense, Lakshman and his mother, they said that Sudha sari accidentally caught fire as she was heating the milk. So on the basis of this evidence, the trial court convicted Lakshman, his mother Shakuntala, and also his brother-in-law Subhash Chandra, and sentenced them all the 3 to death. So in November 1983, the three accused went to High Court to appeal. This is the appellate system. Appeal against the verdict of the trial court. The High Court, after hearing all the arguments, they decided Sudha had died of this accidental cause, fire caused by the kerosene stove. So Lakshman, Shakuntala and Subhash Chandra were acquitted. But in 1980s, the women group across the country spoke out against the dowry death, and they protested on this decision. So they held demonstration, filed a separate appeal against the High Court decision in the Supreme Court through Indian Federation of Women Lawyers. So this case went to the Supreme Court. So in 1985, Supreme Court heard this appeal against the acquittal of Lakshman and two of his family members. The Supreme Court heard the arguments of the lawyer and reached a decision that was different from the High Court. They found Lakshman and mother guilty, but they acquitted the brother-in-law because they didn't find enough evidence against their brother-in-law. So the Supreme Court decided to send the accused to prison for life. So the subordinate court is more commonly known as in many different names. This includes the trial court, the court of the district judge, the additional session judge, then chief judicial magistrate, metropolitan magistrate, civil judge. See, this is the picture of Chhattisgarh, that is which is Raipur district court of Chhattisgarh. So what are the different branches of the legal system? What are the different branches? As we see that dowry death was there, falls within the category, you can say, crime against society, and this is a violation of criminal law. In addition to this criminal law, the legal system also deals with the civil law cases. So let us understand between the difference or the significant differences between the criminal and civil law. So criminal law deals with conduct or act that the law defines as offenses. For instance, theft, harassing a woman, bringing more dowry, murder. While the civil law deals with any harm to the rights or injury to the rights of individual. For instance, disputes relating to sale of land, purchase of good, rent matters and divorce cases. In criminal law, it usually begins with a FIR, first information report, with the police who investigate the crime, after which a case is filed in the court. While civil law, a petition has to be filed before the relevant court by affected party only. If it is a matter of, say, rent matter, either the landlord or tenant can file a case. In criminal law, if it is found guilty, the accused can be sent to jail and also fined. While civil law, the court gives the specific relief asked for it. For instance, in a case where it is between landlord and tenant, the court can order the flat to be vacated and pending rent to be paid by the tenant. So does everyone have access to court? This is a big question. Let me show you that these are certain pictures. First picture, second, third and fourth. So this is the picture in 2001, the drought in Rajasthan and Orissa. This happened, and that millions faced an acute shortage of food. So what can happen? What can be done on this? Even this second picture shows that the government godowns were full of grain, but it was eaten by cats. See, there was a drought, and since the stuff was there, but eaten by animals or rodents. So what we understand when we say, does everyone have access to court? Everyone has a right to go to the court, but it doesn't happen because say there are certain people who are not so rich, and the courts are available to everyone, but there are vast majority of the people who are poor. The legal procedure, they involve a lot of money and paperwork that takes up a lot of time. So for a poor person who cannot read and whose family depends on a daily wage, the idea of going to court to get justice, it often seems difficult or remote. So in response to this, Supreme Court in early 1980s devised a mechanism of PIL, Public Litigation Interest Litigation, PIL, Public Interest Litigation, to increase the access to justice. What it says, it allows any individual or organization to file a PIL in the High Court or the Supreme Court on behalf of those whose rights are being violated. So the procedure has also been simplified. Even a letter or a telegram, the Supreme Court and High Court can take a PIL, right? So PIL secured, it was used to secure justice on a large number of issues like rescuing bonded laborers from inhuman working conditions, securing the release of prisoners in Bihar who had already completed the jail term and their punishment term was complete. So this is the midday meal. You can see the children eating, and this is the midday meal. This also happened because of the PIL. So we talked about two pictures. Now what happened because of this? This hunger amidst plenty, that is, hunger is there. People are hungry, but still there are a lot of food in the godowns. So what happened? According to Article 21, the PUCL filed a PIL. PUCL, People Union of Civil Liberties, they filed a PIL that it is the right of food also for the citizen of the country. So the Supreme Court actually they have ruled that the state had a duty, responsibility to provide food for all. That is how this started. Now every government institution, government school, they have to provide the midday meal to the students. So for the common person, access to court is to injustice. The court exercise a crucial role, but sometimes it may take some time. So the fundamental rights, as we just saw, that the right to food, it came up on the basis of, or when this midday meal scheme happened because of the PIL by certain people, certain individual and organization. But there are also courts, or there are also court judgments that people don't believe. They say that they are against the interest of the common person. For instance, activists who work on the issues of, say, the right of shelter, housing of the poor, believe that the recent judgment on evictions are a far cry for earlier judgment. So there is a case of Olga Teles versus Bombay Municipal Corporation. They had tried to protect the livelihoods of slum dwellers. So it may happen that certain judgments may not be for the people. They don't seem to be okay. So this issue, as we just saw, that the phrase is very important: justice delayed is justice denied. That is, even when we have a justice system, it is also important to bring the justice in time. If you see, these are the family members showing the pictures of 43 Muslims of Hashimpura, Meerut, killed in 22 May 1987. So the family is seeking justice for over 20 years and nothing has happened. Only, this actually was transferred to Delhi from the state of Uttar Pradesh. The trial is still ongoing. 19 provincial armed, the constabulary, PSE men are facing criminal prosecution for alleged murder and other offences. But by 2007, only 3 prosecution witnesses has been examined. So justice delayed is justice denied. This is the strength as on 1 November 2014, that how many judges we have. So in spite of all these, there is no denying that the judiciary is playing a crucial role. It is upholding the, you can say, the spirit of constitution and the fundamental rights of citizen. We are just, the judiciary is holding, and it is a key feature of our democracy. There is a glossary. Acquit means this refers to the court declaring the person is not guilty of the crime which he or she was tried for by the court. And to appeal means, this is in the context of this chapter, this refers to the petition filed before a higher court to hear a case that has already been decided by a lower court. And compensation means money given to make amends for an injury or a loss. And eviction means removal of person from land homes that they are currently living in. And violation means the act of breaking law as well as the breach of infringement of fundamental rights. So this is all about this chapter. Thank you so much. Take care of yourself.